Thank you. Our next speaker is a professor at Suffolk University Law School. Michael Rustad is a law professor, an author, and a television commentator. Let me see if I can get this right. He holds a BA degree from the University of North Dakota, an MA from the University of Maryland College Park. He has a PhD from Boston College. He has a Juris Doctor from Suffolk University Law School, and he has an LLM from Harvard University. Can we get someone qualified up here? Not only that, prior to becoming a law professor, he was a sociologist. He wrote the first book on women in the military. I believe it was called Women in Khakis. And in addition to that, he wrote the first treatise on global internet law. And he also has taught as a researcher at Wellesley College and at Boston College. Please welcome Professor Michael Rustad, who will talk about cyber torts.
Thanks very much. I'm really honored to be here. This 51st anniversary of Unsafe at Any Speed, when Ralph Nader wrote the book, when it was published, product liability was kind of where cyber torts are, a sleepy backwater. Product liability had a whole number of liability shields. Strict liability had yet to evolve. And the automobiles of that period were dangerously defective. The cars I grew up with in the 1950s and 1960s did not have airbags, I assure you. They didn't have seat belts. They didn't have padded dashboards. Ashtrays were not recessed. So if you had contact with the interior of the car, you could lose your favorite eye to a jagged edge of an ashtray. Decorative fins on these automobiles posed a hazard to pedestrians who could be impaled on the fin. So decorations and style were far more important than safety. During this era, they blamed the carnage on highways on the nut behind the wheel, on the driver. There was never a view to look at automobile design. It was kind of like blaming Pearl Harbor for World War II. What was Pearl Harbor doing out there in the Pacific anyway? So the built-in dangers of the automobile that was illuminated and galvanized by Ralph Nader was a lightning bolt on the legal landscape that jump-started the entire field of product liability. It changed not only the automobile industry, but all American consumer products. All Americans are safer thanks to Ralph Nader and his consumer product safety work over the last 50 years. Shortly after Ralph's book was published, the American Law Institute passed the Restatement Second of Product Liability, which recognized strict product liability. And state after state adopted the rule that if there's a product that was dangerously defective, either in design or failure to warn or manufacturing defect, and it caused damages to the consumer, they shall recover. Less than a year after Ralph's book was published, the agency that was to become the National Highway Traffic Safety Administration began its mission to save lives, prevent injuries, and reduce automobile accidents. His work gave us remedies, real remedies as consumers. He was the one that broke through power, that helped to galvanize this field that we now take for granted. We take for granted that products are safety. They've been tested in a laboratory and do not need to be dodged in a home. We no longer have exploding Drano cans. These problems are designed out. The state of cyber torts is much like the field of product liability when Ralph was writing his book. It's a field that is frankly largely stillborn. It is largely stillborn because of two forces. One is what Peggy Radin just talked about, the use of contract law to eliminate tort remedies. Terms of service, which incorporate harsh, one-sided, pre-dispute arbitration clauses, shortened statutes of limitation, caps on damages, just completed a study of social media sites, looked at 329 terms of service. What a boring task that is. The caps on damages were between $1 and $100. Guess what? The fee for an American Arbitration Association is $200 for a consumer arbitration fee. So those cases give, in fact, the social media site a liability shield, a tort-free zone. And you know, the potential for cyber torts is staggering. It's all occurred since 1995 when the World Wide Web became commercialized. New platforms are creating new cyber vulnerabilities. We now do banking online. We don't think about it. We have so many. Facebook, for example. Facebook has 1 billion members. We talk about Google. Google, every minute of every day, there's more than 2 million per minute searches. And there's a lot of single people out there. Tinder, for example, there's 700,000 swipes per minute. Staggering amount of potential tort liability. YouTube, every minute, 2.78 million videos being seen. You know, I coined the term legal lag, and I think that's what we have with cyber torts today. They haven't evolved. They're stillborn. They're what one of President Bush's, George W. Bush's, closest advisors suggested, that we keep tort law small so we can drown it in the bathtub. This is what's happened to cyber torts. There's two forces. We know that cyber torts, that businesses have robust cyber tort remedies. We know that just a few months ago, large companies lobbied Congress and were able to convince Congress to enact the Defend Trade Secrets Act, which gives a private cause of action to those businesses who suffer misappropriation of their trade secrets. We know that from studying cyber torts, that business torts, we know that trade libel cases, fraud cases, interference with contracts, they are strong causes of action. The problem is that negligence and strict liability has yet to evolve. Sure, consumers have robust remedies against other consumers. My talk will focus on the two reasons why consumers do not have remedies for negligence and strict liability. The first is the one-sided contracts, the terms of use. And the second is a federal shield. You heard about charitable immunity from Mitchell Garbadian. In Massachusetts, we have a $20,000 cap. Well, all of cyberspace, all businesses who have a website have an absolute immunity from liability for user-generated content on their websites. This means that a revenge porn website where we have an ongoing tort, you can call it invasion of privacy, intentional infliction of emotional distress, defamation, there's no duty to take down under current U.S. law. Section 230 was passed when the internet was in its infancy. 1996, the first year actually of the World Wide Web. And it had a purpose to protect the infant industry. But now, fast forward 21 years later, do all websites need an absolute liability for torts that are committed by third parties? But I think the most serious problem of why cyber torts have not evolved is this. Imagine a world in which businesses can redirect all consumer lawsuits away from state and federal courts into secret tribunals in which privately hired judges decide cases without precedents and with only limited grounds of appeal. Under forced, secretive arbitration, it is the arbitration provider, and the rules are selected by the arbitration provider as opposed to legislation. This is private tort reform. I want you to visualize, not only is this a secret proceeding without published opinions, visualize further that the social media providers, the social software licensors, place these clauses, thousands of words, into the core, into the interior of terms of service agreements. We have empirical research that these terms of service agreements are never read. Even if they were read, the terms of use are composed of complex terminology. I did a content analysis about the reading level of these terms of service, and they're drafted at the high school level, grade 12. The problem is that the average high school graduate in America reads only at the 9th grade level, not the 12th grade level. But what's more serious is that the foreclosure of rights clauses, things like caps on damages, things like a shortened statute of limitation, things like mandatory arbitration, and the worst innovation of all, the anti-class action waiver. Pamela Gilbert spoke this morning about the benefits class actions are keys to the courtroom door for small money damages. But when you have a cap on damages between $1 and $100, and you have a prohibition about forming or even joining a class action, as Richard Posner might say, Judge Posner, only a moron would file a lawsuit of where the costs far exceed the amount at stake. So what we have, in fact, is a liability-free zone, a tort-free zone. And I think that explains why torts are largely stillborn, at least for consumers. In my study, I found 42% of all social media sites, 42%. I studied 188 sites, included pre-dispute mandatory arbitration. Caps on damages were incorporated at most social media sites. Shortened statutes of limitation. I've saw statutes of limitations that were only 30 days long. And yet these are part of these rolling contracts where the provider reserves the right to unilaterally change or modify the contract at any time, which Instagram did, by the way, in January 2013. They sent notice that we had reserved the right to change the contract and instituted pre-dispute mandatory arbitration. Instagram, owned by Facebook, shows the possibility that large companies, Google Fiber recently chose pre-dispute mandatory arbitration, that this is the trend. These are gotcha clauses, hard damages caps, limitations on remedy that are significantly below the cost of filing. So in effect, what we have, encouraged by the U.S. Supreme Court, which is coddling habitual corporate defendants in general through their endorsement of mandatory arbitration in cases like Concepcion, have constructed a liability-free zone. And these rights foreclosure clauses, I just wanted to mention a couple, just that I'm not making this up. There was a social media application, and here's the extent of their arbitration clause. This is not a legal fiction. All disputes will be resolved through arbitrary proceedings recognized by the state of Nevada. I thought at least they were truthful. So what do they mean? What do they mean by what rules, what rights are foreclosed? No notice to the consumer that they're waiving their right, their Seventh Amendment right to jury, their right of discovery, their right to appellate process. In fact, if you click yes to that, you agree to arbitrary proceedings. So maybe we should have ordeals by stoning or water or other arbitrary proceedings. Another arbitration clause that I reviewed was from Ketchup, which is also a social media site. And Ketchup, by the way, chooses the choice of forum being in the United Kingdom. Any dispute relating to any way to any visit or access of Ketchup shall be submitted in binding arbitration in Newbury, England. Now, Newbury, England might be a perfectly nice place to vacation, but I'm not sure that there would be any person who would ever have a meaningful remedy. Another website, all controversies shall be settled by binding arbitration in accordance with the Indian Arbitration Act of 1996. Any controversy or claim shall be arbitrated on an individual basis and shall not be consolidated in any arbitration with any claim or controversy of any person. The arbitration shall be conducted in Mumbai, India. So the clause actually had only 181 words, but yet it was buried 2,288 words into the agreement. So the total words in the terms of service were 4,000, and they were buried very deep. So this is a social media site for shopping reviews and products and places. So I'm wondering, what did you click today? Did you agree to arbitration in India or to have no class action? So I did the second thing. You might assume that people wouldn't file these claims. Now we have the major, we looked at 188 social media providers, and we looked at the leading arbitration providers, and they were the American Arbitration Association and JAMS. Those are the two largest. And so we wanted to see whether any social media claims had ever been adjudicated through these arbitration filings. I found that Instagram, for example, had not a single filing, let alone an award, since January 2013. Of course, Instagram had 50 billion at a minimum that are subject to this arbitration clause. It seems incredible that 50 billion consumers would not have at least had one complaint against Instagram. So why this drought of arbitration filings? I think it's explained by the fact that the cost exceeds what is at stake. And when you look at others, you look at Facebook has not, other than Instagram has not instituted it, but a number of others have. And the pattern is the same. I found literally 4 filings in an entire decade. So my talk should be rather very short talk on cyber torts, because when you talk about 4 cyber torts in one decade. The second force I wanted to talk to you this afternoon about is Section 230 of the Communication Decency Act. That sounds like something good, doesn't it? Decency Act, right? This was a part of the telecommunications reforms in 1996. And Congress actually had a very narrow statutory shield from liability, that websites would not be liable as publishers, which is basically publisher liability for defamation. And it makes sense that if they had to monitor, for example, all of their websites for any kind of person who posted something that was defamatory, it may increase the cost of doing business. So far, so good. And who were the parties that lobbied for this? Well, there was a council at that time, was AOL, which was then one of the largest service providers. The problem was not with the original statute, but with what courts have done with it. So courts soon stretched it from publishers' liability to distributors' liability. They then extended it to the intentional infliction of emotional distress. They then extended it to the tort of negligence. So basically you had, honey, I've shrunk the kids, honey, I bloated the kids. So this immunity basically gives a broad shield from liability. You can't sue. And so this is one of the things that you might have a case like in Illinois State University, which was a case of a group of college wrestlers who were secretly filmed while they were undressing and showering, and the films were sold on a website, of course, offshore, right? So the primary wrongdoers who did the filming, they are free from legal process. The young athletes got a very large judgment against them, but that judgment is not collectible. So they filed suit against the website that's getting revenue, and the district court in Illinois, dismissed it, Section 230. In fact, there was not even a duty to take down these films. So I'm wondering that when you have a shield of liability, whether it's a charitable shield, historically we had things like family immunities. A wife that was abused by her husband could not sue the husband, and the policy rationale was to foster family harmony. You know, after World War II, family immunities and even charitable immunities have gone to the ash bin of history. Recently, there have been a few courts that have found ways to try to find some wiggle room around the Section 230. But the most recent case on the revenge porn was a case called GoDaddy, and they found no duty. So we need another Ralph Nader who can help us challenge Section 230 of the CDA and challenge these harsh contracts in order for CyberTorch to grow and flourish and fulfill its historic mission of protecting us all. Thank you.